In RICO cases, threshold amount for corrupt activity applies to each individual, not to criminal enterprise. State of Ohio v. Jeffrey Stevens and State of Ohio v. Zachary Bondurant. Case number 2012-2003 and case number 2012-2006. 4th District Court of Appeals, Highland County.
The whole Corrupt Practices Act is focused on organized crime, and it flowed originally from our attempts to deal with the mafia at the federal level, and then it kind of trickled down to the states.
To hold that only those actors transacting more than $500 or $1,000 be guilty of crimes of the enterprise would allow those who commit violent crimes on behalf of the enterprise and never touch a dollar to walk away with a misdemeanor assault or an aggravated assault charge. Maybe the enforcer who and the 4th District Court of Appeals appreciated this argument. The enforcer who goes and punches somebody in the jaw because he hasn't paid for his drugs, but that person never actually gets money and doesn't handle any drugs. They are an enforcer. Should they not be punished with the enterprise? I absolutely think that they should be.
Everybody has a role to play in these organizations, but one thing I am concerned. $500 seems awfully low to be mentioned in a statute that is aimed at drug rings and that sort of thing. What is the rationale, for that?
I'm not sure what the rationale is, but I will advise the court, and I brought this up at the trial court level too. The $500 has been raised now to $1,000 with the passage of House Bill 86. It was raised similarly to every property crime in the Ohio Revised Code. I'm not sure that the $500 has anything to do with drugs at all, but rather refers back in the statute to the property crimes that are listed there, because that's how they would become felonies.
Yes, you can read it the way the state argues, and I'm not going to dispute that that's a reasonable interpretation. But you can also read it that it centers on the individual's activity. And I think that makes more sense, because if we're going to put the hammer of RICO on and escalate from an F5 to an F1, it makes more sense to say we want to make certain that you as an individual are actually, there's a nexus of enough connectivity, enough action, enough commitment to this enterprise. And what the General Assembly has done is they've said, we're going to put a size limit. When you look at a criminal statute and you say, look, you could interpret it this way, you could interpret it this way, both are reasonable, this one favors the defendant, this one favors the state, we have a system for a reason to say, in those cases, it has to favor the defendant.
The corrupt activity convictions of 2 men for participating in a Highland County drug ring were overturned by the Supreme Court of Ohio on May 13, 2014, because their drug sales did not meet the required statutory amounts. The court ruled that the threshold monetary amount for engaging in a pattern of corrupt activity in the state's racketeering and organized crime law must be applied to each individual in a criminal enterprise, not to the enterprise as a whole. Unless a person is involved in transactions on behalf of the enterprise in an amount equal to or greater than the statutory threshold, that person is not susceptible to being prosecuted under Ohio RICO statutes. Justice William M. O'Neill wrote in the lead opinion, "The person can still be prosecuted for the underlying drug charges, as defendants were in this case, but the defendant's first-degree felony convictions under Ohio's RICO statutes must be overturned." At the time that Zachary Bondurant and Jeffrey Stevens were convicted, that amount was $500. The law has since been amended, and the threshold is now $1,000. The court's decision reverses the judgment of the 4th District Court of Appeals.